At this point you probably expect me to say that we need social justice as a counter-argument, but in reality, at this point social justice doesn't have an argument. Making a petition, or registration of opponents to social justice and feminist education, is a tragic diversion, because social justice and gender studies position is apocryphal, and should be exposed as so. It should not be a petition to expose public opinion. If it is not the intention to abolish it altogether, it is a waste of time and minds, especially if this is a weak stand for fears of losing subscribers or income. As a pinnacle of online representation, endows you with moral responsibilities to advocate for those without the ability to reach as many people as you can. To demonstrate the honesty of this statement, I will embarrassingly admit I only have 6 subscribers. I risk public scorn with this admonition, show how ineffectual my stand would be, and demonstrate the power you have to affect change. If the roles were reversed you would ask the same of me. This may be unfair to expect as much, but it was yourself who defined what you stand for, and the reasons you announced why you started your channel. If you are in a position to do more, why wouldn't you do so? Revision is not the answer to SJW religious doctrine, because disciples will always try to press their teachings into the classroom, like a Christian at an abortion clinic, if not restrained by law. People don't have the time for half measures, as SJWs can usually become social, jostle, warriors, who will press more liberal migration of pro-Sharia law and anti-democracy settlers into your neighborhood under the justification of academic discourse of justice that has no challenger and no scientific evidence. This is why it should be abolished on the legal grounds of academic misconduct. In UK law, you have the ability to use this petition to invoke the statute Abuse of the Public's Trust, Article 2.153, which says, an element of culpability which is not restricted to corruption or dishonesty but which must be of such a degree that the misconduct impugned is calculated to injure the public interest so as to call for condemnation and punishment. Means it is up to the public to decide the eligibility of grounds for starting a legal investigation or proceedings of Crown prosecution under culpable misconduct academically in the public education system. Taxpayers' money has been fraudulently directed into these illegal institutions. Your petition would fall under public condemnation and corruption of municipal culpability, so why are you just taking a head count? You yourself illustrated by the response to a statement, quote, students know that it's unsubstantiated, a declaration by adversarial positions for the reclaimants of social justice courses, demonstrating their knowledge that it is not factually based, but advertise in the course outline that they are. If they wish to express this doctrine, they should do it at a pulpit or street corner, not in a public or national education institution. This statement of the lack of substantiation outlines not only the general disregard they have for the law, but the belief that they are above the law on moral grounds, which is more worthy of a cult, not an institution. The fact that they frame their courses in a way leads a student into believing this course complies with real education statutes when it is not, making it not only not comply with ethical standards of education law, but it infringes on false advertising, falling under consumer law as well. In Australia, Academic Misconduct Statute 2014, Legislative Instruments Act 2003, and La Trobe University Act 1964 make these courses illegal in Australia as well, but there is no person with enough influence to inspire enough citizens to advocate prosecution. Without evidence to back their claim and curriculum, they cannot call it a discipline or education. Under this premise alone they should be closed down. Freedom of speech protects the individual, not the institution. Legally outlined in law is the legislation to prohibit the violations of academic integrity and ethics, and this should be advocated, not whitewashed with the fear to offend. Social justice and feminism completely cross this line. They cite no academic or experimental evidence for these beliefs, making it a religion, and this makes it illegal for it to be taught in public universities and schools, but no one will prosecute it for fear of backlash, rather than being found wrong. A petition against social justice is not good enough in rationality or in legality unless it calls for the complete abolishment of this practice. It needs to abate the fear of personal backlash against prosecutors, and only people like you can supply that security of consensus. This is not an attempt to shame you, but an appeal that can be only done in this way because of the immense amount of text responses you get a day. A petition is a good start, but it certainly should not be the end. It is illegal to teach Jesus in public classroom, so it should be illegal to teach other religions, such as social justice and feminism, in the classroom too. This violates the statutes of public-funded education. If social justice and feminism can't supply accurate, statistically quantifiable objective peer review evidence, it should be abolished by course of the law and academic ethics. We would not tolerate Black Panther acceptance studies or helter-skelter doctrine in other universities, so why are we tiptoeing around that an ideology that teaches the same identical principles? One that deliberately contradicts developmental psychology, a real science, and openly renounces the scientific method. So please don't piss away our only chance for reform by being tentative in your convictions. There is nothing wrong with asking for a legal and academic evaluation instead of the suspension. They have been given the right to impartial treatment on this issue, and they have only flicked us the bird and appropriated national funds to apparently study sexist glaciers and done no research to justify their inclusion in academic society. I will say that again, no academic study, not even qualitative research, let alone a quantitative one, just self-flagellating unanimity and self-congratulatory confirmation. You have already demonstrated the social studies experiment that they have co-opted to be completely flawed, methodologically unsound, and measures nothing. They already have had their chance. This is not a measured response, it is just another capitulation. It is only sensible to consider this an abortion of thought and education, which infringes on the rights of citizens for access to unbiased and objective education within the United Kingdom, Europe, Australia, Canada, New Zealand and America universally. Therefore it should be treated as hostile to a nation and a subversion of state authority and constitutional statutes as stated by the UK Education Act 1996, Chapter 2 Article 11, Chapter 3, 13 and 13A. The same can be said for the Canadian Education Amendment Act 1980. Why bring out a petition when you can take out a legal injunction and even a class action lawsuit against educational institutions in your country supplying these courses under false pretenses and gross lack of already legally defined ethical responsibility? Riddle me this backlash. What if you were proven by peer review to be liars and charlatans who are literally breaking the law? If so, the repercussions of plagiarism are severe, so how severe should be the repercussions for fabrication, misappropriation and misrepresentation? Individuals have protection of speech. Institutions do not. They have the responsibility of ethical conduct. It is time to take back our respective national dignity. End communication.